Okay, so we'll do the state, and the first thing is with the state is about the contract. So I just like to go through each paragraph. So paragraph 1 is obviously the buyer and the seller. It's pretty basic. Paragraph 2, just remember that 2 is the description. The most common description is lot and block. That's going to be for urban, so most of America. Another legal description will be meets and bounds. That's always going to start with beginning at a point, point of beginning, starting at a beginning point. There's going to be monuments. A monument is like a rod that's stuck in the ground where surveyors can decide where the property line starts and stops. And then the third type of survey is called a government survey system. Its synonym name is rectangular survey system. There's always going to be a grid overlay of the property because it's so big. And there's going to be ranges. Those are your north-south lines. And townships are your east-west. And then there'll be a section. And that's pre-colonial, Western civilization, Tonto, the Lone Ranger, Montana, all right? In paragraph 2 with the description, 2D delta is exclusions. So if you ever had a question on, where would a seller exclude that? 2D delta is exclusions. And the way somebody would exclude it is sever it. Severing makes real property personal again. Annexation makes personal real. So how do you make personal property that you buy at Home Depot real property? By annexation, to add. And then paragraph 2E earning is for mineral rights. They convey naturally to the buyer. So in order for a seller to exclude that, it'd have to be on a reservation of mineral rights. Okay, but if there's no reservation of mineral rights, the buyer gets the mineral rights by default. Paragraph 3 is always 3A plus 3B equals 3C. The down payment is 3A. 3B, boy, is the sum of all financing. You add 3A and 3B and you get 3C. It'll always equal. When it comes to 3B, the sum of all financing, if it's a cash transaction, 3B, boy, would be 0 because the down payment would be 3A. It would be equal with the sales price because it'd be cash. But most people don't do cash, so that means 97% of financing is going to come down to only 3 addendums. One's called a seller financing addendum. That's when a seller finances their own home. Who negotiates any of that? It's blank, so it's the parties. The other one is a loan assumption. That's if you're going to assume my loan. And the third one is the most common. It's called third-party financing. It encompasses conventional, FHA, VA, and USDA, and reverse mortgages. Conventional, you can put 5, 10, 15, 20% down. On conventional, if you put 20% down, you're considered low risk, and that's a low loan to value. 80% is your loan to value if you put 20% down. It's like that having 100 ounces. You take 20 ounces out, you have 80% of it left, and that would be low risk for the lender because you drank 20% already, or you put down 20%. FHA, the down payment's always 3.5. And on FHA, you always have to escrow. So there's no option to be able to pay your own taxes every November. VA is 0 down, and so is USDA. USDA, you can only kill a cow where you can get that loan. So that means VA 0 down is the most common 0 down loan in the marketplace. A veteran can buy 0 down at VA on a condo. So those are your 3 financing addendums. You go to paragraph 4, and paragraph 4 is leases of people and things. People means a tenant's already in it, okay? So you see my house, but I'm the owner, but there's tenants in here on a long-term lease. As a buyer, you need to get that lease because the security deposits are going to be transferred over to you. So that's going to be paragraph 4. It'll say that there's a lease already in existence with the current tenant. And then that's leases of people. And then leases of things. The most common one is security systems and solar panels. Those go with the house, not with the seller. So if they're not owned, they're leased, they stay with the house. So the buyer would have to have the knowledge of what those payments are every month, and it could blow the ratios. So the lender wants to know also. Paragraph 5 is always earnest money, option, and title company. So let's first cover title company. Negotiable, who's the title company? We close at a title company. They're a middleman, a hired gun. They're going to go all the way back to sovereignty of soil and check all the way up to today for any liens. They're going to issue a title policy up to the sales price. 2 things the title policy doesn't cover is shortages in survey, which means the surveyor screwed the pooch on your demarcation lines. Title insurance doesn't cover that. There's a separate insurance in the contract. And the other one is marital rights, survivorship rights in a marriage. That's not covered on a title policy. And so let's talk about the two checks, which aren't checks anymore, they're money wires, but the earnest and the option, okay? They're both made out to the title company. They're both delivered in 3 days at midnight, unless the third day is a Saturday, Sunday, or holiday. The earnest money is applied as a down payment towards the buyer's closing costs. The earnest money, a down payment towards the buyer's, the earnest money goes towards the buyer's down payment and then any other closing costs. So the earnest money goes towards the buyer's down payment. The option is a credit towards the sales price. And that's the way Trek will describe it. So the option is a credit towards the sales price. Earnest money is applied towards the buyer's down payment and then any other closing costs. So if you were working with a veteran and the down payment was 0, the earnest money would go towards their closing costs. If the veteran got their closing costs paid, then they get that money back because they didn't need any money to close, but they still might have written an option or earnest money check. All right, so they're both due in 3 days, unless the third day is a Saturday, Sunday, or holiday. That's midnight. They're both made out to the title company. And again, which one is applied towards the down payment? Earnest money. Which one's a credit towards the sales price? The option, okay? The option buys your right to terminate, that you can terminate at 5 p.m. on whatever day it is that's the last day of the option. So nobody knows how many days you bought because it's a blank. Anything that's a blank is negotiable. So who knows what the earnest money is? It's normally 1%, but in this market, it's a lot more because there's no homes on the market. So, it depends. All right, paragraph 6 is what the title company does. So again, paragraph 1 was the buyer and the seller. Paragraph 2 was the description. Paragraph 3A plus 3B equals 3C. Paragraph 4 is leases of people and things. And paragraph 5 is the earnest, option, and the title company. Now we get to paragraph 6, and it's just what does the title company do? They do title work and they check the survey. And that's what it'll talk about. So it talks about the title policy. Who pays the title policy? It's optional because there's 2 boxes. The seller can or the buyer. So if it says who normally pays it, depends. It's negotiable, okay? The title company, who picks the title company, who knows? It's a blank, so it's also negotiable. And it talks about what the title policy doesn't insure. And the 2 main ones are a demarcation problem, a surveyor that screws up, or survivorship rights in a marriage. The big thing on commitment, and I talked about if you were in any of my classes about how when you're dating somebody, you kind of research them for about 20 days. So it's called a title commitment. The title commitment, the title company researches the house to protect the buyer. They want to know who slept with the house. So they go all the way back to sovereignty of soil. They check all the way up to today, and they check for liens and ownership, owners, people, and also the written history. The owners, that's called a chain of title, because a link makes a chain, and that's a sports analogy, like, oh, you're only as strong as your weakest link. So a link makes a chain, that's the owners, all the way back to sovereignty of soil. Abstract to title is the written history. They're going to check both, they're going to issue a clear title policy, but they first are going to make a commitment to that buyer, and they do it 20 days from when they receive the contract, not the effective date. Most days start from the effective date, like your right to terminate is always day 0 on the effective date of the contract. But the title commitment research starts from the day the contract's received at the title company, which could be 3 or 4 days after it's executed. Okay, so just make sure that if you see a question, when is a title commitment sent to a buyer? It's not 20 days from the effective date, it's 20 days from the date the contract's received by the title company. Yeah, so again, that's that. If you ever get a question about the survey, just know that, if the seller has a pre-existing survey, they can furnish it. Generally, a survey is a buyer charge, about $300-400. The main thing on the survey is paragraph 6D. 6D is if you bought my house and wanted to make that room a daycare, you're going to have to know that the HOA in here is okay with it. That the deed restrictions say you can make that child care. Or if you are a speech therapist and wanted to cut the whole walls and make a little school where speech therapy, occupational therapy, physical therapy, it would have to be approved by the deed restrictions or by the HOA. And so in paragraph 6D, you would type in daycare. So if a question says, hey, Susie Smith wants to put a daycare in her house, where would she put that in a contract? 6D. And then there'll be a number of days to object. It's a blank, so nobody knows how many days. So if they say, hey, how many days is there to object if you wanted to put a daycare? It's negotiable. That would be the answer. Whatever's in the paragraph, whatever's agreed between a buyer and a seller. All those are ways to say negotiable. And then you have the HOA, which we know that if the home has an HOA, you'll have a HOA addendum. It's called a property owner association, mandatory membership in a property owner association. And when the buyer gets the HOA docs, they have a free 3-day right to terminate on a house. So think of it like HOA, 3 letters. Whenever the buyer gets the HOA docs on a mandatory HOA, they got 3 days to terminate for any reason. Okay, so that's paragraph 7. When we get to paragraph 7, that's paragraph 6. When we get to paragraph 7, that's basically the property condition. So it's going to talk about the condition of the property. The buyer has a right to get a home inspection. Reasonable times, that's in the contract in paragraph 7A. By a TREC licensed inspector and or someone otherwise permitted by law to do such inspection, like a plumber, a roofer, an engineer, okay? And then it's going to talk about the seller's disclosure. And most of the time, the buyer gets the seller's disclosure. But I'm sure they'll ask you what happens if the buyer doesn't get the seller's disclosure. They got 7 days to terminate. That's how many letters are in sellers. S-E-L-L-E-R-S. So if you just spell out sellers, that's how many days the buyer has to terminate if they don't get the seller's disclosure. So if you had a scenario that said you were buying a home and you were 5 days out from closing and you wanted to terminate, you're out of your right to terminate under the option, what's true about your situation? One answer would say, you never got the seller's disclosure. You have 7 days to terminate. You're 5 days out from closing. That means you can terminate, and you'll get all your earnest money back, okay? So you either have the disclosure, you don't have it, which you get a number of days to get it, and then you have an automatic 7-day right to terminate at midnight. And then there's the other option is the home doesn't require it. And there's 11 exceptions to not having a seller's disclosure. Most of them are like a tax estate, estate sale, a foreclosure. But if you and I own this home together and I was buying you out or you were buying me out, we don't have to do a seller's disclosure for each other because you already have the history of the home and I already have the history of we co-owned it together. And then a new home, never lived in. That means a builder. So a builder never lived in home, okay? There's a little rule about 5% lender required repairs. And that's where you buy this home, you get a home inspection, you're out of your option, but now the appraiser comes out. That's going to make sure the home is worth what you're buying it for. And the appraiser finds 5% in excessive repairs of the sales price and repairs needed. Even if the seller says they'll fix the home, it exceeds the 5% of the sales price, you can back out no matter what. So it's like a last protection for a buyer if the home doesn't, if the home is crap, basically. All right, so that's paragraph 7, and then of course 7H is always going to be the residential service contract. If it asks in the contract who purchases the residential service contract, it's the seller. But the buyer, the verbiage is the buyer buys it, and then the seller reimburses them at closing. The reason they do that is because if the buyer buys it, the seller doesn't have a right to get a refund on it after closing, like try to get a refund back. So this says buyer may purchase. So if it asks who purchases this residential service contract, probably the answer will be buyer. But if it says, and then seller shall reimburse them at closing, because the buyer's never even debited that at closing. They just buy it in the buyer's name so that the seller can't get a refund. Paragraph 8 is going to be if you buy your own home, if you sell your own home, if you have a 10% share in an LLC that's buying it, or a corporation that's buying it, or if you're related to CPS, okay, child, parent, spouse. All right, so just remember that. If it's your in-laws, no. If it's your sibling, no. But a child, parent, spouse, and that's who calls CPS. A child does on a parent or a spouse. When it comes to paragraph 9 is the closing. So that's negotiable. Nobody knows. So who determines the closing date? Buyer and the seller, lender maybe. Make sure that they can get it done in time. And then paragraph 10 is possession. And that means that either I'm going to sell my house and move out the day it funds, or you're going to let me stay in it for a few days, up to how many? 90. Okay?
There's a lease, right?
And there's only two. One's called a buyer's and one's called a seller's, and they're good for 90 days, and they're promulgated. Promulgated means that you have to use those forms if you're addressing that fact. So where you wouldn't do it is in paragraph 11. You wouldn't type in seller to lease house back for 3 days. Because if you marked in paragraph 10, according to a temporary lease, because you either mark upon closing and funding or according to a temporary lease. So if you mark that, then you're going to attach the relevant lease. But you're never going to put here, seller to lease house back for 3 days. Because this paragraph says, insert only factual statements and business details applicable to the sale. TREC prohibits you from adding facts or business details for which there's already an addendum that states the same thing. And that's why you would never put in here, seller lease house back for 3 days. Also, you'd never put in here that you're related to the buyer or the seller, because we do that in paragraph 8. So that's where they get you. They ask you a question like, hey, what would you put in paragraph 11? A, that you're related to your mom? No. B, that you would let the seller lease the house back for 3 days? No. But then they'll do one like this. Anything on a TAR form? Yes, because TAR is our trade association. And they provide us with some forms, but they're not promulgated because only TREC promulgates. And so that's a trick, and that's the answer. Oh, what's on a TAR form? It's now called Texas Realtors. That's their trade association, so it'll be something like that. Then paragraph 11, only thing you put in paragraph 11 is a fact or a business detail not otherwise in a promulgated form. Paragraph 12 is where you ask the seller to pay closing costs for your buyer, okay? Everything else I really don't go over, but I do want you to know paragraph 21. Are you a Cowboy fan? Okay, well, Zeke Elliott, his number's 21. So when he catches the ball, he puts the world on notice. And that's a great way to remember it. That when he catches the ball, he's number 21, he puts the world on notice. Paragraph 21 is notices for the buyer and the seller. So like if I was the buyer and you're my agent, you put my email, you put my phone number. If I was representing you and you were the seller, I put your contact, because that's where the notices will be sent from the title company, okay? So that's a great way to remember. Paragraph 21, notices, the world's put on notice when Zeke catches the ball, notices of the buyer and the seller. Paragraph 22 is just the addendums, okay? If the addendum's not here, you have to mark other. For instance, if you wanted me to leave this table, that would be non-realty, that's personal property. So you put on a non-realty addendum. Well, it's not pre-printed here. So you'd mark that and put non-realty. You're telling me, if I'm the agent representing the seller, that I should be looking for a non-realty addendum. Oh, so this is just where the addendums are attached. Probably the most important paragraph is this one. And that is that's the executed date. If it ever asks you on the test who fills it out, it says right there, broker fills in this date. But really you do. But for test purposes, the broker does. The reason why that's important, because if it's blank, it could lead to confusion. Because your days to terminate start from that date being day 0. So if that was dated June 1 and you bought 10 days, you'd have a right to terminate at 5 p.m. on June 11th. Because on your fingers, you go June 2nd, 3rd, 4th, 5th, 6th, 7th, 8th, 9th, 10th, 11th. And then the right to terminate for a buyer is at 5 p.m. Okay? But that date is very important. Okay?
That one was honored.
Yeah, and you'll be fine. That's all it is getting a refresh. All right, so that's that. Okay, I always like to cover some things that are, just kind of get the mind going. So, number one, we know a literal lake. Okay, a lake is like an ocean and a sea. Ripe river, a river is like a stream. So what's the water right with a stream? Ripe river. What's the water right with the ocean? Literal lake. What's the water right with a sea? Literal lake. Okay? We know there's radon and carbon monoxide. Okay? Radon is a colorless, odorless gas. Can you get it?
He's not here, that's fine.
Oh, that's fine. Radon is a colorless, odorless gas. It's found in the north. It's found from digging up rock to build a basement, and it's cold. So radon rock, basement, cold, north. Those are your key factors. Carbon monoxide is a colorless, odorless gas. The off product of spent gas that's not vented. You breathe in carbon monoxide. That's the most common colorless, odorless gas that you could die from, carbon monoxide. Because radon you'd only find in the north where it's cold to build a basement and you dig it in with rock. Freddie Mac. his initials, Forever Her Love, MC Hammer, okay? VA stands for Veterans Affairs, okay? How does a house sell? You've got to have a motivated buyer and a motivated seller. You've got to have a willing buyer and a willing seller. What is a buyer? Somebody that's ready to buy and qualified to do so. Not somebody in a 5-year lease. That's not a buyer. So if they just ask you a basic question like, what's a buyer? Somebody that's ready to buy and on a timeline to do so. Why does a house sell? Because of a motivated buyer and a motivated seller. Because of a willing buyer and a willing seller. If you're ever asked, do you ever recommend, do you ever discourage an attorney from looking at a contract? Obviously no. Obviously before. But then it comes to how do you get it to the attorney for the client? And you physically give them the check. They drive it back, then you scan it to the listing agent. But you don't ever do anything into an office where it's an attorney-client privilege. We have 2 dates, 1978. One lead, so let's cover that first. That's found in pipes, soil, and paint before 78. And if you have a buyer or a tenant, they have 2 separate addendums on lead. And you'll also give them a pamphlet on lead. The buyer, a lead-based paint addendum, gives the buyer the right to waive or to do a lead-based paint inspection. Okay, it gives them 10 days to do it. So that's going to be important. And then the other thing that's before 1978 is asbestos, or asbestos, however you want to pronounce it, I don't care. Asbestos, the best way to deal with it is, well, number one, it's found in chimneys, it's found in floor tiles, it's got fiberglass in it, and it particulates in the atmosphere. So the best way to deal with it is you put a big Ziploc over it, and it's called encapsulation. Yeah, so, but that's going to be, if you see a question that says friable. Okay, perfect. And then we have the civil rights. So if you get a question on race color, you got to think about when was slavery fought in the Civil War, 1860s. So the first civil rights law is 1866. It protects race color. There's only 7 classes. The next 2 are 1968. Bobby Kennedy was in office. Well, he was running for president of the United States. He got assassinated in LA. And he was an Irish Catholic, Bobby Kennedy. Irish national origin, Catholicism, religion. So there's 4. Race, color, national origin, religion. 1970s, women were marching for equal rights, women's liberation, sex, gender, male or female at birth. That was the 5th class. January this year, Joe Biden added in sexual preference and gender identity. It'll be 2 new, it won't be on the test. The last 2, George Herbert Walker Bush was president in 1988. He was in a wheelchair before his death. So that's handicap status. And then he had a big family at the funeral, familial status, okay? Handicap status covers alcoholism. Chronic alcoholism, alcoholic, that will be a protected class. We know the one class we don't ever, HIV, age-related. Somebody walks into an apartment complex and it says no pets on the outside with 5 exclamation marks, but the tenant that walks in is blind visibly and has a guide dog, there'll be an exception. If the dog makes a mess, the blind person will make the cleanup, okay? They'll still be responsible. Anything that you talk about where a buyer has an issue about possible asbestos or like there's an endangered species on the property or a wetland, that's an environmental addendum. If you're ever asked who is the one that decides flood zones, that's EPA. Okay, EPA for their website for the most up-to-date floodplain. Anywhere that you would have a coastal waterway addendum is going to be where there's a coast. So it's like Corpus or something. In case you get questions on Fannie, Ginnie, and Freddie, Fannie was 1938. She made the market liquid. So what was an entity the government created that made the market liquid and addressed regional imbalances between New York and rural towns? Fannie Mae. Ginnie Mae is the youngest. She's the kid. She's idealistic. She wants free housing, and she's involved with like homeless and community affairs and stuff like that. And then you have that she was born 30 years after Fannie. So Fannie was 38, 68 was Ginnie, and Ginnie was 2, and then at Freddie. And Freddie is an investor also and buys and sells mortgages at Wall Street. Back to what TREC promulgates, residential contracts and some addendum. Okay, what are the contracts at their base form? As is. Okay, these are as is contracts, not option contracts. These are as is. What does TREC not promulgate? Well, commercial, long-term leases, manufactured homes, mobile homes, timeshares, and co-ops. What do they promulgate? Residential contracts and some addendum and those 2 addendum are short-term leases, okay? They also do farm and ranch, condos. Let's talk about condos versus townhomes. The most commonly used contract is the 1 to 4 family. That's for single, duplex, triplex, quadplex, and also townhomes. You own vertically, above you and below you. On a condo, you own horizontally, so that's called horizontal development. Did you ever get that question?
I had one, what does a condo owner own? The airspace above?
No.
The air between the walls?
Yes.
Okay.
Yeah, so basically if this was a 1-bedroom and you were next door in a 1-bedroom condo, this wall was a dividing line. We don't own anything above us or below us. We have tenancy in common, okay? But in that wall, there's an air pocket, and I own 50% my way and you own 50% your way. And so that's on a condo. And then of course on a condo, you don't own anything outside, so there'd be no survey mentioned. In a 1 to 4 family, there is a survey. On condos, I would always say that plurally, condos, that's 6 letters. That's how many days the buyer has to terminate when they don't get their HOA docs. So just to recap, sellers, 7. HOA on a house, 3. Condos, 6, for when they get the mandatory HOAs. And then of course, probably a good idea to know what Trella, 39, what they do. They tell us you can't sell your house by lottery or raffle. You can't guarantee the future or profit, and you can't put a sign in somebody's yard without a written listing agreement. And then Trex 49, 4 letters, Trex 49, they're the cops. They regulate Trella. Their number 1 job is to protect the public. They give and take your license, and then they promulgate. And in order to promulgate, that's just stamping for use. Promulgate just means to publish. So in order to promulgate, they need a lawyer to draft, write, revise, and that's the broker lawyer committee. Whenever you hear the word lawyer, that's unlucky, that's 13 people. And every committee has 6 brokers. And lawyers will always have an equal number of brokers. So that means 6 brokers and 6 lawyers, that's 12. That leaves 1 lay person to equal 13 on the broker lawyer committee. And they always draft, write, revise, draft, write, revise. We use the promulgated forms minus 2 exceptions. The seller decides, you need to get it good. The seller decides they want to write their own contract, or the seller's lawyer. So basically a lawyer prepared form or the seller. Minus that, you're going to use a promulgated form. Okay? Everything in Texas is broker to broker. Okay? Only a broker can sue for commission. Only a broker can receive a commission. Every time you work with somebody, your goal is to turn them into a customer from a client to a client from a customer. Everybody who ever meets a customer, which begs the question now that we start talking about agency, the IBS. So what is the TREC prescribed form that you give to somebody on your first face-to-face where there's substantive talk? The IBS. Do they have to initial it? No. You just have to prove you gave it to them. So obviously initialing it is the best. Does that create agency? No. Do you ever give that when you write an offer up? No, that's way too late. There's only one way you create a client, and that's them signing an employment contract. And there's really only 3. There's a listing agreement, a buyer rep, and a management agreement. And the management agreement is between a property owner and a property manager. And the property manager is the broker. And the property manager, the broker, becomes a general agent of the property owner. Okay? So a property manager becomes a general agent of a property owner. And that's a general agent. A general agent. And then you'll have a buyer rep agreement and a listing agreement that turns a customer into a client. Can a buyer rep be for 1 day? Sure. Can it be for 1 house? Sure. Can it be for the state of Texas? Sure. I mean, it's just, you'll sign an ICA, an independent contract agreement with your broker, and that's it. You're independent. You're on your own. You're your own boss. So any question you're ever asked on the test that says, is your broker going to give you workers' comp if you roll your ankle? No. Are you going to get a quota? Are you told to mandatorily do anything? No. That's always going to be the case. All right, fixtures. Anything that's a fixture will be personal property, made real by annexation. Annexation means to add, sever means to separate. So if you make personal real property, it's by annexation. If you make real property back to personal, it's by severance. Yeah, he's out there. You just don't walk in.
Hey, just come in.
Okay, so that's a fixture. Then you have a trade fixture. That would be if you're a tenant and this is my house and I'm the landlord and you cut hair in the garage. So That's all right. So you have to see where. So and I'm recording it, so I'll send it to both of y'all before we leave. Oh yeah, you're fine. Whatever you want. So a trade fixture, that would be where you're cutting here. You've screwed in a trade fixture swivel chair into the garage floor, and you leave. Your lease is up. If you don't take it, it becomes a landlord's. So if you're late on rent, it becomes a landlord's. Implements or crops. Crops are implements, and they're also personal property of the tenant. So if you're a tenant farmer and I'm a tenant landlord, and you sign a January to January year lease, 5 years, and every June you have a harvest, well, that means that's your first year, your second year, your third year, your fourth year, your lease is up. You still have one more time to come harvest those crops, which are called implements because they're personal property and they belong to you. Even an owner that sells their house can come one more time to harvest those. What's true about land before this was even built is that it was indestructible. It can burn, but not to the core in the middle of the earth, so it would be indestructible. It can't be moved, and it has characteristics of non-homogeneity. That means there's no two pieces of land that are the same, because non-homo is non-sameness. And then we have the 3 types of legal descriptions, which I've already talked about. I'm gonna hit one more time. Anything in this subdivision will be described as lot and block, because it's the most common, and most of America is gonna be lot and block because it's urban. You're gonna have meets and bounds. That would be like Gunner, Royce City, Rockwall County, where you might be on 4 or 5 acres. It'll always have start at the beginning at a point, starting at a beginning point, starting at a beginning point. Go north 500 feet, go east 500 feet, go south 600 feet, go back to your point of beginning. You just made a square. You start at the point of beginning, and by God, you'll end at the point of beginning. And that's always going to have terminal points and angles, meets and bounds, terminal points and angles, and a lot and block has a map or a plat. And then the third one is like government survey system, rectangular survey system, very, very much like Montana, Wyoming, okay? And then we know that there's a right that we have to buy property called the allodial system, and in it is our one right in private property to buy it. And when you buy property, you get a title policy. They research all the way back to the first owner, which is the government. That's sovereignty of the soil all the way up to today. And we know that's our only right. It's called the allodial system, spelled all O-dial, allodial. The government has 4 rights, and always the first right is ad valorem. Ad valorem means according to value in English. It's the #1 lien on a property. And every time you get ad valorem, you need an ass to tell you what your home is worth. The assessed value, assessor, assessment, but it always starts with ass, A-S-S, because they never come into the house. So they're going to take the assessed value times the tax rate, it'll equal ad valorem. The tax rate's called mills. And Don Quixote, he fought hundreds and thousands of windmills. So what's mills? It's hundreds per thousands. And that just means that if I'm being taxed at 2.4%, that's 2.4 times 1,000. So if I have 100,000, it's 2,400. If I just had 1,000, it'd be $2.40, okay? And so taxation is the first one, and then you have police power or eminent domain. Police power is the regulation and control through private property with zoning, and you can break zoning with a variance. The variance is a one-time use, okay? And then you have eminent domain. That's the taking of private property for public use. That's just an overall definition. If they knocked on your door and said, we're gonna take it, that's called condemnation. And then if they took all your property but left you like that much and you couldn't do anything with it, if you sued the government, that's called inverse condemnation. And then the last one is cheat, and that's when you die without a will, spouse, or heirs. The government decides where your property goes. If you die without a will, spouse, or heirs, you've also died intestate, which is just without a will. In means without. Inconsistent, without consistency. Intestate, without a will. If you drop off the in on inconsistent, you're consistent. If you drop off the in on intestate, you're testate. That means you died with a will. So if you died with a will, there'll be an executor, and you'll get the property by devise or devisee. If you die without a will, I always say that you're in a descent, in a depression, hell, whatever, and that's how you get the property when you get it without a will. A court will appoint an administrator who will decide who gets the property. And if you get it, you got it by descent, and you're called a descendant, okay? Joint tenancy and tenancy in common, I'll spend a lot of time on it. Joint tenancy basically means that you and I buy a property, married or unmarried, and we buy it joint tenancy. You have a will having it go to tuck, and when you die, it still goes to me because we bought a joint tenancy and it has a right of survivalship. Not to be confused with we buy tenancy in common. We buy tenancy in common and she has a will having to go to you. She meets her demise, it does go to you because the tenancy in common doesn't have a right of survivalship, right? And that's the main thing to know. A tenancy in common, you don't have a divided interest. You have an undivided interest in the total, the entirety, okay? What can an unlicensed assistant do? Answer the phone, greet, and put stuff in a computer. Basically, anything that requires a response back, they can't do. It's probably a good idea to know about VA. VA, the down payment is generally 0, which means the loan to value is 100. A veteran, when they buy a home, the lender will not send an appraiser out as much as they'll send what's called a CRV, a certificate of reasonable value. I mean, the appraisal will be an appraiser, but when they give the appraisal to the lender, it's called a CRV, certificate of reasonable value. It's the same thing as if you bought that for $1, but before closing, I appraised it for 90 cents. Because you were buying it as a veteran, you'd have the right to not buy it, period, even if you had no right to terminate. So if it comes in below the value, the veteran has a right to back out no matter what. That appraisal is called a CRV, certificate of reasonable value. And again, the down payment is 0, generally speaking. Eligibility and words like eligibility and entitlement are going to go with VA all the time, okay? Adjustable rate mortgage means it fluctuates with the market. It's pretty common sense. Fixed means it's fixed forever. Old car is probably something that would be good to know. Obedience, loyalty, disclosure, confidentiality, accountability, reasonable care. O is obedience. That's like Moses come down from the mountain and he has the law of God, says be obedient. So law and obedience go together. You follow the lawful instruction of your client, obedience, O. Loyalty is pretty basic. D is disclosure of all known facts. C is confidentiality. It's the one letter that lasts forever. So confidentiality lasts forever. Accountability is because you'll be dealing with money. And reasonable care is just exercise prudence and caution. Old car. When you sign a buyer rep agreement or when you sign a listing agreement, you give old car to the client. They don't give it back to you. So that's the only thing you give to a client when you have them is old car. Okay? You can't sign for them. You can't do shit. It's the most limited relationship you'll ever have called special agency, and it's effective when you have a buyer rep or a listing sign, and then you owe old car to them. They owe back to you compensation, maybe some approved reimbursement of something you might have paid for them. They have to perform and work with you, but the main one is compensation. That's what the employment contract dictates. There's 3 fields that we talk about in real estate: a green field, a brown field, and a gray field. And then there's wetlands, which you don't want to build on. But you have a green field, that's like undeveloped grass, virgin grass. That's perfect. Then you have a dog that you let poop on the green field and you never let him clean it, you never cleaned it up. So the green field turned to a brown field. That's the worst chemical that you could ever, very undesirable to ever build on, a brown field. And then you have that gray area, like a vacant Starbucks or a vacant Walmart. It was already something, but now it's vacant. You don't know what it's going to be zoned for next, okay? What is void versus voidable? Voidable means that one party can non-perform against another. Voidable, like a minor buys a home. Void means you're high, drunk, or incapacitated. Cuckoo, like that, all right? But it doesn't necessarily mean you're crazy. It could be you enter into a contract with somebody that has dementia, or a diagnosis that they have a memory problem, or they don't have the capacity to act like an adult, or the reasoning of an adult. Then it would be void from the beginning, which means unenforceable, invalid. And of course, everything in writing in real estate for conveyance has to perform the Statute of Frauds. Statute of Frauds means that it's got to be in writing if it's for sale. But a year lease under 1 year can be oral or handshake. So a 7-month lease over the phone is valid and enforceable. I mean, how you would enforce it if there was a disagreement, nobody knows. But technically, for test purposes, it's enforceable and valid if it's under 1 year handshake or lease. But nothing on the sale is ever enforceable unless it's in writing, and that's because of Statute of Frauds. Deceptive Trade Practice Act, we should know a little bit about it. Every state has its own. You want water?
Oh yeah, I'll take a word.
Okay, I'll get it real quick. So, statute of frauds is in writing, and statute of frauds is in writing, and the Deceptive Trade Practice Act is one on you. Deceptive Trade Practice Act basically comes into play when you go list a house. There's a document that you should give to the seller and wait for, and that's the seller's disclosure. That falls under the Texas Deceptive Trade Practice Act. So if the seller were to deceive you and not tell you about something, and the buyer found out, the buyer could sue, and the best defense would be the seller's disclosure. And in a court, the judge would rule treble damages, so that's 3 times the damage. If they didn't tell you, then you'll be indemnified. Indemnification means I only know what you tell me, and if you don't tell me something, how would I know it? So if the seller never told you, you can't possibly knowingly know. That's always the word, knowingly know. You don't want to be intentional. You want to have non-intentionality. Like, no, I didn't intentionally know that. I didn't knowingly know that. Because if you did, you would be liable also in a deceptive trade practice lawsuit. Because as a realtor and as a license holder and a broker, we provide brokerage called a service, and the seller provides a good called a home. Home is a good and brokerage is services. So that's how we're brought into a deceptive trade practice lawsuit. Again, I talked about the title commitment before you got here. It's like you're dating somebody. Are you married? Single? Oh yeah, you told me you're single. So you're dating somebody and you're like, hey, I like you. And they're like, well, I like you. And you're like, hey, why don't I check you out for about 20 days? And you're gonna check them out for 20 days. It's the same that somebody does with a house. So it's 20 days from when the contract's received at the title company. You should know the IBS is given to a buyer, seller, tenant, landlord at first face-to-face or where there's substantive talk. It doesn't create agency. It's a TREC prescribed disclosure. If you had a scenario that said that you met Veronica, you showed her 10 homes this morning. This morning you gave her a TREC prescribed disclosure. After showing her 10 homes and eating at Whataburger 3 times, you're now writing up an offer. Is that a time to talk to Veronica about her wants and needs? No, because it never followed up and said you signed an employment contract. All you did was get a TREC prescribed disclosure signed. That's the IBS. So right now you're working with a customer, and anything she tells you is not protected. So that's kind of how they, most likely would do something like that. If you're in default as a buyer or seller, that means that you're out of contract, you're breaching the contract. There's 3 remedies. One remedy is only able to be used if the buyer's in default, and that's liquidated damages. The buyer writes an earnest money check, generally speaking, but they don't really have to, right? Because you don't have to write any checks to buy a home. You have to have consideration, but it could be what? Love and affection. Okay, so you don't necessarily even have to have money when you buy a home, but most of the time there is. So if the buyer writes a $5,000 earnest money check and 2 days before closing, the buyer goes, yeah, I don't think I want to buy this home. Then if the seller doesn't want to file a suit against them and just wants to move on and get them out of their life, the seller could say, hey, just give me the earnest money, we'll call it a day. And that's called liquidated damages. The other one is called monetary damages. Nobody knows what that amount is. That's a court. And then the one that is the only remedy, because there's only 3, the only remedy that could enforce the terms of the contract, meaning the buyer goes, no, I want to buy the house. I'm going to sue you to sell it. Or the seller goes, no, I need you to buy it. I'm going to sue you to buy it. That's called specific performance. And that's the only remedy that could enforce the terms of the contract. So whenever you see buyers in default and earnest money, it's a no-brainer. It's liquidated damages. When you see an unknown amount of money, that's going to be monetary damages. And when you see the only remedy that could enforce the terms of the contract, that's always going to be specific performance. Again, the broker-lawyer committee is the one that drafts, writes, revises. Good funds, when a buyer goes to closing, it needs to be a cashier's check or a money order. It's going to be made out to the title company. Ballpark earnest money is about 1%. What is the down payment? The down payment is 3A. 3A in the contract is the down payment. 3B is the sum of all financing. You add 3A plus 3B, you get 3C. If you get a question about what is the down payment applied towards, it's what the earnest money is applied towards, it's going to be the down payment at closing. What's a co-op? Well, it depends. If it's talking about a type of real estate, a co-op is a stock transaction. It's not even a real estate transaction. It's where you own stock in a company that owns a building. Okay, so that's called a co-op, and you don't have a specific unit. Whenever I make an offer to buy her a drink, I'm the offeror. She's the offeree. She's receiving, and I'm giving the offer. If she counters, she becomes the offeror. And she sent it to me, and I'm receiving. I'm the offeree. If I counter, it goes back to her. I'm the offeror, and you're the offeree. Anytime you're the offeree, that's called the power of acceptance. Because all you got to do is initial the counter, and you just closed the house. You bought it, okay? So if you ever get a question that says, who has the power of acceptance? Cowboy Stars, offeror, offeree. It's going to be the power of acceptance is with the offeree, okay? But the offeree and the offeror always change. Whenever there's a counter, the one countering is the offeror and the one receiving is the offeree. Seller's disclosure, known facts. You should know the term indemnification. That means that you're only liable for what the principal tells you. What is it when you take somebody trying to do them a favor because they're Chinese near a Chinese grocery store and tell them that's where they should live? That's steering and channeling. We don't do that. So steering and channeling is taking someone to or away from an area based on a protected class, not to be confused with redlining, which is taking a buyer or seller to or away from an area based on the location. Or it's not really that. It's a lender, a bank, that says, hey, I'm not going to give you a loan, not because you're a young couple or because of you, but because of the location of the property. And that's called redlining. So banks can be guilty of it. Anytime you're under contract and a seller gets material changes to their subdivision that are significant, they need to let the buyer know immediately, not like a day after closing. It's just common sense. So, all right, I've done that. All right, I think that's good for the state. So.